Good morning. Welcome to the Supreme Court of the United Kingdom, where today we are hearing an appeal in the matter of Crown Prosecution Service against Aquila Advisory Limited. The appeal raises the question whether, in circumstances where a proprietary claim is brought by a company against its directors to recover proceeds of crime recovered in breach of fiduciary duty, can that proprietary claim be asserted in priority to a confiscation order obtained by the Crown Prosecution Service? I'm Lord Lloyd-Jones, and I'm sitting today with Lord Sales.
Good morning.
Lord Burrows.
Good morning.
Lord Stevens.
Good morning.
And Lady Rose.
Good morning.
The appellant, the Crown Prosecution Service, is represented by Andrew Sutcliffe, Queen's Counsel, Julian Christopher, Queen's Counsel, and Anne Jevons. Respondent, Aquila Advisory Limited, is represented by Stuart Ritchie, Queen's Counsel, Martin Evans, Queen's Counsel, and Sam Neyman. Mr. Sutcliffe.
My lady, my lords, in our written case, we dealt with attribution first and illegality second. In my oral submissions, I'm going to take them the other way round. In other words, I want to start on the assumption that the conduct of VTL's directors can be attributed to the company. Then, having seen how Patel and Mirza would deal with the issues, I will go back and explain why that assumption is correct. The reason I'm dealing with it in this way is because I respectfully endorse what was said to this court by Jonathan Crowe, Queen's Counsel, in Singularis and Daiwa. As my lords, Lord Lloyd-Jones and Lord Sales may recall, he said at page 679C of the bundle, I don't need to ask you to go there, logically, the first defence to look at is illegality, not attribution. Attribution depends on the context in which the question arises, see Bilter and Nazir, and can only be relevant here as part of the analysis of the defence of illegality. One cannot, as the defendant has done, begin by presenting an argument on attribution in the abstract. We respectfully agree with that submission. Attribution is like construction. It is an iterative process. At each stage of the analysis, you have to sense check the attribution rule that you're applying against the relevant context. You perform that sense check when considering the claim, and you perform the sense check again when considering the defences raised by the defendant. There are no abstract rules of attribution. That is, in fact, the very point of Bilter. So by taking the illegality defence first, I will provide the relevant context for the attribution defence. Now, on illegality, we say that the issues in this case are resolved without difficulty when considered as part of the three-stage assessment directed by Patel. The policy considerations brought into the open by the first two stages of that assessment are to be welcomed. Those considerations were previously masked by the attribution analysis in Bilter, which was a convenient way to avoid the problems caused by the straitjacketed analysis of illegality emanating from the Tinsley and Milligan line of authority. Then, when we turn to attribution, I have two submissions. First, the true ratio of Bilter and Nazir is that where a company has been the victim of wrongdoing by its directors, or of which its directors had notice, that wrongdoing or knowledge of the directors should not be attributed to the company as a defence to a claim brought against them by the company's liquidators for the loss suffered by the company as a result of the wrongdoing. And I've taken that from the headnote. That reasoning should not be extended to prevent a defence of illegality ever being available in a dispute over the proceeds of a breach of fiduciary duty. Every case will depend on its context, and the context here is the CPS trying to confiscate those gains because they are not just the proceeds of a breach of fiduciary duty. They are first and foremost also the proceeds of crime. That is a different context to Bilter and Nazir, which was a dispute only between a company and its directors, and there was no intervention by the public authorities. Bilter was a case about fiduciary responsibility. This is a case about criminal responsibility. Secondly, we will submit that Bilter and Nazir should not be read as giving overriding effect to the wrong done to the company at the expense of other matters relevant to illegality policy. If you were to read it in that way, it would be at odds with the range of factors analysis in Patel and Mirza, and would result in Bilter undermining the new approach to illegality in Patel. We say that the balancing act in Patel and the contextual approach in Bilter should lead to the same answer. Before I address you on those matters, I wish to make three brief points on the facts. The first and most important is that, as was stated by the judge who presided over the criminal trial and found by Mr. Justice Mann at first instance in these proceedings, that's paragraph 34, little c of his judgment at page 178 of the bundle, this tax scheme was a fraud from start to finish. Aquila's attempt to attribute some value to the company's IP is entirely misconceived. The IP had nothing to do with the fictitious increase in value of the shares which enabled the fraud to be carried out. And I ask you to read in your own time paragraphs 34 and 35 of the judgment of Lord Justice Davis in the Court of Criminal Appeal, when he rejected an identical argument made on behalf of one of the directors in July 2014. That's at pages 371 and 372 of the bundle. The same argument was addressed in detail by the judge at the criminal trial at pages 346 to 353 with the same conclusion. There is no connection or correlation between the company's IP and the £4.55 million to which the directors helped themselves. Put another way, no part of the 4.55 million was generated by the IP. Every penny was generated by the tax fraud that formed the basis of the criminal offence in respect of which the directors were found guilty by a jury. In a world where no crime had been committed, these funds would not exist. The second point is that, as Aquila accepted in its note sent to the court last week, HMRC's recovery actions have not resulted in full recovery to HMRC. The taxpayer remains out of pocket as a consequence of the fraud, and there is every reason for effect to be given to the confiscation orders. Third, VTL stood to make a very substantial profit from this fraud, some £26 million, as set out in paragraph 33.1 of our case at page 57 of the bundle. Moreover, there's no evidence that VTL has suffered any loss as a result of this fraud. In the confiscation proceedings, the court rejected Aquila's argument, made as VTL's assignee, that it was a victim of the fraud under Section 6, subsection 6 of the Proceeds of Crime Act. That was can be found recorded in their counsel's skeleton argument, paragraphs 2 and 3 on page 355 of the bundle. Furthermore, as Aquila's recent note also accepts, none of VTL's clients sought to argue in the confiscation proceeding that they were victims of the fraud. If this appeal is dismissed and the monies subject to the confiscation orders released to Aquila, no part of those monies will be paid to any of VTL's unsecured creditors. Under the terms of the deed of assignment between Aquila and the liquidators of Vantis PLC and VTL, only 25% of net recoveries from these proceedings, that is, after deduction of legal costs and what are called investigation costs, will be paid to the secured creditor of Vantis PLC, which is a bank. Moreover, as Aquila also accepts in its note, to the extent that it is of any relevance, this fraudulent tax scheme was not the cause of VTL's insolvency. Vantis Group went into liquidation as a result of the collapse in 2009 of Stanford International Bank. I turn now to our submissions on illegality. In paragraph 29 of its case, at pages 105 and 106 of the bundle, under the heading Standing of the CPS as Intervener, Aquila submits that the CPS can have no better defense to its proprietary claim than the directors. Before I address the position of the CPS, I ask you to consider the position of the defendants themselves following Aquila's decision to assert its proprietary claim in late 2013. Change the facts. Imagine that the CPS had not intervened in March 2014. Suppose, as is likely, that the directors and their wives had then defended Aquila's claim on the basis that the confiscation orders had been made and they were bound to comply with those orders. They could have added that failure to do so exposed the directors to further criminal sanctions, including a sentence of 2 years in the case of Mr. Fakeney and 3 years in the case of Mr. Perrin, years imprisonment, respectively. They could also have argued that if they transferred the monies to Aquila, both they and Aquila would be committing money laundering offences, a point which I will make good shortly. In those circumstances, the defendants would have had powerful reasons for arguing that it would cause inconsistency in the law if the court did not apply the illegality defence against Aquila. The effect of denying Aquila's claim is to permit the confiscation orders to take effect as intended by the Proceeds of Crime legislation and the criminal courts which granted the confiscation orders. Enforcing the confiscation orders means the directors are deprived of their ill-gotten gain. The prophylactic fiduciary policy so strenuously urged upon this court by Aquila in support of enforcing the claims, enforcing the duties of fiduciaries, is met, we submit, much more effectively by ensuring that none of those criminally responsible, and by that I mean both VTL and its directors, profit from the proceeds of their crime. a denial of Aquila's claim and allowing the confiscation orders to be complied with has the prophylactic effect of making it clear that crime does not pay and ensuring the integrity of the civil and criminal jurisdictions in this country. These are not special arguments of the CPS that require the CPS to have special standing to raise them. They could have been raised just as effectively by the defendants themselves. My Lord Sales.
Yes, thank you, Mr. Sutcliffe. Just going back to the example you gave, if the CPS had not intervened and the directors and wives had been left defending themselves against Aquila's claims, if Aquila had won in those proceedings, would there have been scope for the confiscation orders to have been revisited by the criminal court?
My Lord, I don't believe that there were, but could I reflect on that and come back to you?
Yes, certainly. But what I have in mind is the criminal court would have made its confiscation orders on the supposition that the monies represented property in the hands of the directors and their wives. But then there's, on your example, subsequent civil proceedings, which, let us suppose, established that in fact they held the monies on trust for Aquila, so it's Aquila's property. So the basis on which the confiscation order was made would have been falsified. One might have thought that there would be some mechanism for going back to the criminal court to get it to look at the matter again once the falsified assumption on which it had proceeded had been exposed.
My Lord, I believe the answer to your Lordship's question as supplied to me by Mr. Christopher, who has more experience of these matters in relation to confiscation orders than I do, is concerns the question of a certificate of inadequacy, which would only happen to be available on these facts, I understand, because the directors had no other assets. It could not avail them if they had other assets too, as they may well have done. The certificate of inadequacy does not alter the benefit figure. Aquila's claim has no impact on the benefit figure either. The directors, to the extent that that other assets were available, would have been left with meeting the confiscation order under threat of imprisonment, as well as Aquila's claim.
Yes, thank you.
But Mr. Sutcliffe, in those circumstances, the whole of the proceeds of crime proceedings would have proceeded on a false basis. Benefits figure would have been assessed on the basis that the 4.55 million was in fact the property of the directors. I mean, surely that there was some procedure under the Proceeds of Crime Act under which that could be corrected once it's established that it was held on constructive trust.
My Lord, my understanding is the way that it worked, the benefit figure was, as your Lordship rightly says, 4.55 million, but the available amount, which was fixed by reference to the recoverable amount, was, as the court will have seen, lower in both those cases. I think 800,000 in the case of one of the directors and 650,000 in the case of another. And I think that what would have happened was that in answer, as I answered in relation to my Lord Sales, there would have been a trip back to the criminal court in order to obtain a certificate of inadequacy, which on these facts I'm understood I understand, would have been available because the directors had no other assets. But if they did have other assets, then they clearly profited from the crime, because the only proprietary interest being claimed is in respect of the assets that are currently frozen, represented by the confiscation amounts.
Thank you.
My lords, can I now turn to the test to Patel itself and the proper application of the three-stage test in Patel, which is not contentious, at least in this court. And for convenience, we've included the relevant paragraph 120 of Lord Toulson's judgment in paragraph 29 of Appendix 2 to our case, which is at pages 94 and 95 of the bundle. And at stage A, the court has to consider the underlying purpose of the prohibition which has been transgressed and ask whether that purpose will be enhanced by denial of the claim. In Henderson, at paragraph 119, which is page 1615 of the bundle, we don't need to go there, Lord Hamblin clarified that stage A is not confined to the specific purpose of the prohibition transgressed. Other policy considerations that impact on the consistency of the law and integrity of the legal system will also fall to be taken into account. So applied to this case, the specific purpose of the prohibition which has been transgressed is to prevent tax fraud. However, it is also permissible, indeed we would submit necessary, to consider in this first stage the fact that denial of the claim will enable the confiscation orders to be complied with and will prevent money laundering offences being committed. At stage B, the court has to consider any other relevant public policy on which the denial of the claim may have an impact. Stage B operates conversely to stage A, and applied to this case, the arguments relied on by Aquila in favour of being permitted to advance the claim all concern the importance of fiduciary accountability. Stage C, the court has to consider whether denial of the claim would be a proportionate response to the illegality, bearing in mind that punishment is a matter for the criminal courts. As Lord Hamblin said in Henderson at paragraph 123, page 1616 of the bundle, this is a disproportionality check rather than a proportionality requirement. And in our submission, the application of stages A and B of the Patel test to the undisputed facts of this case produces the clear conclusion that the claim should be denied. And we say that you never get to the disproportionality check at stage C. I commenced the analysis by making an obvious but very important point. Given that the directors were the directing mind and will of VTL for the purposes of the fraud, it is indisputable that under the criminal law, VTL would be held criminally liable for the illegality. And we do not understand Aquila to dispute this. I need only refer you to the well-known case of Tesco and Natras, tab 50 of the bundle, applied as recently as last year in SFO and Barclays, tab 47, and in particular to the holding at H5 on page 2427, and paragraph 15 of Lord Justice Davis's judgment, sitting at first instance at page 2431 of the bundle. The illegality doctrine is therefore engaged. So starting at stage A, the policy reasons which justify the denial of this claim primarily relate to the Proceeds of Crime Act 2002. But I want to clear a few other points out of the way first. It is common ground that the purpose of the prohibition, which has been transgressed, is to discourage the dishonest evasion of tax. That's paragraph 132 of Aquila's case at page 138. Eviction of my Lord, Lord Stevens.
Why then were VTL not prosecuted, and why is there an ability in the Proceeds of Crime Act to hold the ring whilst the prosecution is taking place?
My Lord, my understanding as to why they weren't prosecuted is they were insolvent. They did not have the proceeds of the crime available.
Well, they had the benefit of a constructive trust.
They were legally responsible for the crime, but the actual proceeds of the crime were held by the directors and were made subject to, who were convicted after trial and then made subject to the confiscation orders. But my Lord, I understand that the prosecutor, the CPS, had to make a decision as to whether or not also to prosecute the CPS. And I think the important point, in answer to my Lord's question, is that no proprietary interest had been claimed at the stage of the criminal trial. And so it was only subsequent to that, after the confiscation order had been made, that that Aquila, who'd taken the assignment of the claim from the liquidators of VTL, then sought a proprietary injunction in the civil court, and also amended its claim to claim a proprietary interest. So I think that is the reason why the CPS did not include the VTL as a defendant.
But is that not a lack of appreciation that they had a proprietary interest, and therefore they could have been prosecuted if you were intent on securing the money? Rather than that, you had to wait for their claim to be made before proceeding against them.
No claim had been asserted to a proprietary interest, and one's got to bear in mind these were the proceeds of crime. So it would be a surprising claim in any event for the CPS for such a claim to be made, that the proprietary interest somehow trumped the position with regard to proceeds of crime, and therefore I think the CPS were entirely justified in taking the view that the directors should be prosecuted and confiscation orders sought in respect of the proceeds, which they themselves had. They were doubly dishonest. They'd stolen those proceeds from the company itself, having devised this tax scheme in the company's name. But my lord, my lady, my lords, the evasion of tax is a serious offence which costs the public billions of pounds each year. If Aquila's claim is denied, it will not have the result of allowing the directors to hold on to their ill-gotten gains. Those ill-gotten gains will be paid pursuant to the confiscation orders to the state. It is, of course, true that the directors acted dishonestly and breached their fiduciary duties to VTL, not just by devising this dishonest tax evasion scheme in the company's name, but also by diverting part of the proceeds of that scheme into their own pockets. Had the directors not acted in what I've called that doubly dishonest manner, the proceeds of the tax fraud would have remained with the company. The company itself could have been convicted of the same offence of cheating the revenue as the directors, and could itself have been made subject to a confiscation order. There's no evidence that VTL or its clients have suffered any loss. It's accepted that if Aquila is successful in this appeal, no part of the monies recovered would be paid to VTL's unsecured creditors. There are strong policy reasons for denying Aquila's claim and ensuring that the company which is criminally responsible for this fraud does not recover any of the proceeds of that fraud. Put another way, there is no policy or other reason why, given the existence of the confiscation orders, the knowledge of its fraudulent directors should not be attributed to the company. Turning to the policy underlying the Proceeds of Crime Act, for which I will use the acronym POCA, I start with a concise summary provided by Mr. Justice, my Lord Stevens.
I do apologize, but I want to be absolutely clear I understand it. The CPS did have a vehicle by virtue of indicting and prosecuting VTL to recover this money. Point one. They could have also commenced civil proceedings against VTL on the basis that they held a proprietary interest in the proceeds of crime. Point two. Both of which would have been successful if followed. I can understand you putting forward reasons as why it wasn't followed, but if those techniques had been used, they would have been successful. Well, VTL would have been prosecuted and convicted and an order made against them in the criminal proceedings, and VTL would have been subject to a recovery order in the proceeds of crime civil proceedings.
Well, my lord, can I answer that simply by saying that the evidence was clear. Yes, this was a fraud conducted in the name of the company, but the directors had removed 4.55 million from the fraud. In fact, they were monies, I believe, paid to the tax avoidance companies in the Channel Islands. So they'd taken back. They were the ones who had benefited in the sum of 4.55 million. A thief benefits in the sum stolen, even though the property is never his, and it was in the public interest. And that is the consideration which the CPS has to bear very much in mind, that those directors were prosecuted given what they had done. The money wasn't with the company. And we deal with this, I think, in paragraphs 65.3 and 65.4 of our case.
But what I wanted to do, sorry, Mr. Sutcliffe, for interrupting. What I wanted to do was to be absolutely certain and clear in my own mind that if those techniques had been used, they would have been successful, and that is the CPS case. I can understand you putting forward policy reasons for not doing it, but was that available to the CPS?
No, my lord. For this reason, because confiscation orders having been obtained against the directors, which I submit was the proper thing to do, given that the directors had received the proceeds of the crime, VTL would have resisted a confiscation order being made against it. And moreover, it would have been barred, that confiscation order would have been barred by section 308, subsection 9 of POCA, because that prevents double recovery. In other words, there can only be one confiscation order in respect of the same proceeds of crime. And that is why it's simply not, would not have been possible, even had it been thought to be in the public interest for the company to be put in the frame, so to speak, to have been indicted, and then for I should make clear, where I referred to section 308 subsection 9, and I'm going to be coming on to this, what that subsection does is it bars a civil recovery claim. So in my submission, having obtained confiscation orders from the directors over those amounts,
and again, I do apologize for interrupting, but in advance of obtaining the confiscation orders in the criminal proceedings, could you not have commenced civil proceedings against the company? So you wouldn't have been barred at that stage.
My lord, is this in circumstances where the directors hadn't even been indicted, where there had been? I mean,
on the facts of this case.
Well, my lord, again, in my submission, that would have been simply not a possible thing for the CPS to have done for this reason. The company was insolvent. It didn't have the purpose of bringing proceedings under Part 5, the civil recovery provisions of Part 5, were to recover criminal property in the hands of that defendant. The money was not with VTL. The money was with the directors, and it was thought appropriate that they should be convicted and then a confiscation order applied for. Yes, either had the choice, in answer to my lord's question, the choice was this. Either the CPS went for confiscation orders in the way that it did, or it went for civil recovery under Part 5. It couldn't do both. And that is why Section 308, subsection 9 prevents effectively what is thought to be double recovery. And in this situation, it was thought in the public interest to indict and then convict the directors and then apply for confiscation orders. So in my respectful submission, the CPS did absolutely the right thing in doing what it did. I believe I was...
Mr. Sutcliffe, I think Lord Sales has a question.
Sorry, just before you move on from this, might it not be said that your analysis simply reflects the fact that the CPS made a mistake as to the true proprietary position? You keep saying that they didn't pursue VTL because it was insolvent, but in fact, VTL was the beneficiary under a constructive trust for the 4.55 million.
Well,
and as I understand it, it's implicit in what you're saying that if the CPS had appreciated that, then yes, they would have pursued VTL by one of the routes that my lord has indicated.
Well, my lord, two answers to that, if I may. The first is that it's a bit rough to suggest that the CPS made a mistake in circumstances where there'd been no proprietary claim asserted by VTL or its liquidators on its behalf until after the confiscation order had been made. It was only by amendment that the proprietary interest was claimed in October, November 2013, after the confiscation order was made back in April. And the real reason why...
Well, forgive me for coming in there, but I think you're making the point that, yes, they made a mistake. I mean, unless and until limitation bites and prevents a claim from being brought for a constructive trust, there is going to be a danger in this sort of situation that the company does, in fact, own the property represented by the monies in the hands of the directors, isn't there?
Well, my lord, again, if I said this brings me on to my second point. The CPS in the public interest is not and does not need to be concerned with who owns the property, particularly if no claim to ownership has been made. It is concerned with who has got the property, who has benefited from it. And the position was, so far as the CPS is concerned, is that VTL, the company, the vehicle that had been used to commit this crime, had no money, didn't have the property. The property was in the hands of the directors and their wives. And so those parties were indicted, convicted, and confiscation orders. In my special submission, the CPS didn't make a mistake. It acted perfectly properly in the public interest, and it would not have been in the public interest to have either indicted the company in those circumstances or to have proceeded in the ways that is being suggested. And so I was referring to a passage from Mr. Justice Collins' judgment back in 2004 in the case of Director of Asset Recovery Agency, as the NCA was then known, and T, where his lordship said it is in the public interest that, and this is talking about the proceeds of crime legislation, so Parliament has decided that no one shall profit from ill-gotten gains if they can be identified. And through the 2002 Act, Parliament has empowered the CPS, the NCA, the SFO, HMRC, and the FCA to act to recover the proceeds of crime on behalf of the state. Can I ask you to consider what was said by Lord Neuberger in Patel at paragraphs 184 and 185 on pages 643 and 644 of the bundle, and to note in particular the 4 lines at the top of page 644. Could I ask the court to consider those 2 paragraphs? In my submission, looking at the top of page 644, the first 4 lines, this is just such a case where the effect of the order of the lower courts is to prevent the directors from complying with the terms of the confiscation orders made against them under pocket, where the state has already taken steps which the effect of acceding to a claim in the civil court would undermine. That plainly should be taken into account. And my Lord Sales.
Might it not be said that the point that Lord Neuberger is making is that you could, under POCA, if you implemented its procedures properly, proceed both against the directors and against the company, but you didn't in this case?
Well, my Lord, I again would submit that isn't a fair analysis of the position. And could I refer the court to paragraph 65.3 and 65.4 of our case, which is where we anticipated that this point might be made. I can simply, because it was a point made by the Court of Appeal, so we were addressing there the Court of Appeal. And what we say in paragraph 65.3 is on the Court of Appeal's reasoning. In the present case, it would also have been necessary to prosecute all 4 of the other companies through which the tax schemes were implemented, since each of those companies could equally have brought a proprietary claim in the same way as VTL. And the suggestion in any event that the CPS should routinely spend public funds indicting and obtaining convictions against companies in liquidation solely to preempt them later undermining confiscation orders obtained against the directors is highly unattractive, particularly where, as here, the civil court is readily able to apply the relevant principles to the accepted facts in order to identify that the company would have been attributed with the director's state of mind for the purposes of criminal liability and has the tools available to it to prevent such deliberate manipulation of the justice system. So that is our answer to the point that the CPS somehow made a mistake. With the greatest respect, it didn't. And can I ask the court now to
Mr.
look...
Sutcliffe, just before you move on from that point, could I ask, as a matter of law, could the CPS prosecute VTL now?
It's in liquidation. I will see, because I'm not a prosecutor, I'll ask Mr. Christopher if he can assist me answering my Lord's question, but it would seem a substantial waste of public funds, because what would happen, presumably, I don't know how the evidence would, but effectively the directors have already been prosecuted many years ago for the same crime and convicted of it. And it's very significant that in those criminal proceedings, VTL sought to argue, Aquila, as assignee of VTL, sought to argue that it was a victim of this crime, and that proposition was rejected by the Crown Court judge. But I think it's I think yes, Mr. Christopher's answer is that in theory, VTL could be prosecuted now, many years later, but Aquila could not. And prosecuting VTL would not prevent a claim by Aquila.
No, but what I was wondering is whether if VTL were prosecuted now, there would be scope for Part 5 POCA proceedings then being brought against Aquila as a person holding the proceeds of crime.
The answer to that, my lord, is no, there would not be, because of section 308, subsection 9 of POCA, which prevents, which provides that in circumstances where a confiscation order has been made, Part 5 proceedings cannot be brought. My lord,
Couldn't be prosecuted now for money laundering.
Well, that is, my lord is right. Aquila could be prosecuted on the basis of a fresh money laundering offence by taking possession of the sums frozen under the confiscation order. That is quite right.
And then you would be able to recover from them because it would be a separate crime and hadn't been taken into account.
My lord, that is absolutely right. But we submit that a far better route is actually to deny their claim.
Well, why not just apply the statute? well, why not actually use the mechanisms set out in the Proceeds of Crime Act and get on with prosecuting people who committed offences?
Well, my lord, but because no offence has yet occurred. The offence would only occur as a result of this claim being allowed. No claim. The moment the monies are frozen,
well, they certainly would have attempted to commit the offence. I think, Mr. Sutcliffe.
It hasn't yet happened, and so it would be premature of the CPS to take that step. And we submit it by far the.
Well, then if it's premature and it is effective civilly, can they then be prosecuted? If the CPS lose this appeal, can they then be prosecuted for money laundering?
My lord, it raises interesting questions to which I will come, if I may, when I'm dealing with Part 7, which is certainly part of my submission. But it is indeed a submission that I make, that there would be a question of offence under Part 7. My lord, I appreciate that some of what I'm about to submit, I may already have covered in my answers to your questions. But can I ask you to look at paragraph 26 of Lord Justice Patton's judgment, in this case at page 162, where his lordship refers to the same paragraph in Lord Neuberger's judgment in Patel and expresses the view that none of the members of the court in Patel who considered this matter, and I quote from the passage 5 lines from the end of the paragraph, appear to have thought that the making of a confiscation order should alter or influence the outcome dictated by the relevant common law principles. With the greatest respect, it's not at all clear on what basis Lord Neuberger's paragraph 185, in particular the 4 lines at the top of page 644 that I just showed you, stands as authority for ignoring the confiscation orders or for ignoring the consequence of those orders not being complied with on the steps already taken by the state to recover these criminal proceeds. And whilst we're on page 162, can I ask you to read paragraph 25 of Lord Justice Patton's judgment, in particular the final sentence, where it suggested the company should have been indicted for this crime so that if convicted, a confiscation order should have been sought against the company. And I appreciate I've already covered this, but we respectfully submit that is a wholly impractical suggestion with far-reaching ramifications for the reasons that I've given in paragraph 65 of our case. And it's also nonsensical for the simple reason that the civil court is perfectly capable of working out for itself that the company has, through its directors, as its directing mind and will, acted illegally and is seeking to recover criminal property. The company doesn't need to be indicted and convicted in order for the civil court to appreciate the fact that applying the standard rules of attribution, the company acted criminally. And they're the strongest possible policy reasons for ensuring that confiscation orders are complied with, steps already taken by the relevant enforcement authority under POC are not undermined. The property subject to the confiscation orders has been found to be criminal proceeds and has been taken into account in the calculation of the director's benefit under Part 2 of POC. And as Aquila accepts, and this is paragraph 93 of their case on page 129 of the bundle, had these confiscation orders not been made under Part 2, it would have been open to the CPS to seek civil recovery orders against whomsoever held this criminal property under the provisions of Part 5. But it's common ground, that route is no longer available to the CPS because confiscation orders have been made, and that is because of section 308 subsection 9, the provision designed to prevent double recovery. And the CPS's inability to bring civil recovery proceedings against Aquila under Part 5 to recover this criminal property is a strong policy reason for denying Aquila's claim. A further strong policy reason for denying Aquila's claim is that the effect of allowing the claim is to condone the commission of money laundering offences under Part 7 of POCA. And let me explain why. Property subject to the confiscation orders is criminal property. Sections 327, that's page 1178, and 329, 1182, make it an offence for the defendants to transfer the property to Aquila and for Aquila to receive it. The fact that Aquila may claim to have a beneficial interest in that property doesn't mean that the property ceases to be criminal property. That is clear from sections 340, subsections 3 to 5 of POCA at page 1244 of the bundle. Now, in an attempt to avoid this conclusion, Aquila seeks to argue, this is paragraph 110, page 133 of the bundle, that a court order for the transfer of funds would protect it from committing a money laundering offence under Part 7. Bowman and Fells, the authority Aquila relies on to support the submission, concerns section 328 of POCA and the rights of lawyers to conduct litigation on behalf of their clients. Section 328 provides that a person commits an offence if he enters into or becomes concerned in an arrangement which he knows or suspects facilitates by whatever means the acquisition, retention, use or control of criminal property by or on behalf of another person. Nobody is contending that the court will be committing a facilitation offence under section 328. What we do say is that the court should think long and hard before ordering a party to do something that it is illegal under POCA. There can be no doubt that the effect of acceding to Aquila's claim would be to condone the commission of money laundering offences under sections 327 and 329. This is another strong policy reason for denying the claim. Aquila seeks to rely on two hypothetical examples to try to avoid the difficulties it faces in relation to money laundering. The first concerns a handbag retrieved by an innocent witness from the thief. It's a bad example. No offence is committed by the witness, either in possession of the handbag or on restoring it to its rightful owner, because as soon as it is retrieved from the thief, it is no longer criminal property as defined by section 340, subsection 3, because it no longer, and I quote, constitutes a person's benefit from criminal conduct or represents such a benefit. The second example given by Aquila concerns a constructive trust arising over a bribe such as considered in FHR. There's no doubt that the bribe constitutes criminal property. Indeed, I'm instructed that it would be routine for a confiscation order to recover the proceeds of a bribe and unheard of for a company to resist confiscation of an illegal bribe received by its convicted employee. But the answer to avoiding the commission of a money laundering offence under sections 327 or 329 is for the company to make an authorised disclosure under the relevant provisions of the Act and to obtain consent to holding on to the bribe. Whether and in what circumstances such consent would or should be forthcoming is another issue. Neither of these examples supports Aquila's argument that a purposive interpretation should be given to the legislation, which has the result of enabling Aquila to obtain this criminal property. We respectfully submit that the courts should be astute not to become involved in sanctioning or in assisting parties to launder criminal property. So in conclusion, on stage A, it is wrong to say that no harm is caused to the integrity of the law by ignoring the confiscation orders made against the directors following their conviction of the offence of cheating the revenue, and allowing Aquila to undermine those orders entirely by obtaining this criminal property for itself. The arguments relied on by Aquila under stage B of Patel in favour of being permitted to advance its claim all concern the importance of fiduciary accountability. My lady.
Just in stage A, I'm not quite sure how fact specific you say that the policy considerations are. You seem to be positing the existence of the confiscation order. You also referred to the fact that it's agreed that the company is insolvent and that if money is recovered, it will go to the bank rather than to the subscriber investors who are also victims of this whole scheme. But I'm not sure whether you accept then that if one tweaks the facts of this case slightly, so for example, although there is clearly a criminal offence committed and the potential for a pocket order, there is no criminal prosecution and there is no order. Or if the company is put into liquidation, but it's not insolvent, and this is a way the liquidators see of getting in some money, either by suing the directors themselves or by selling the cause of action as they have here, and it looks as if that money will then go in part at least to the subscribers and investors who have lost money. Would that different factual situation result in a different answer under stage A of Patel? How much of the factual background is one able to take into account in applying stage A?
My lady, I think the answer to my lady's question is had the company had the money either because it was solvent or it had recovered the money itself from the directors, either because the money hadn't been taken by the directors or it had recovered it from the directors, then the probability is that the company itself would have been indicted and convicted for this fraudulent tax scheme. And in those circumstances, a confiscation order made against the company. I think the important point I'm making in relation to the integrity of the law is that in circumstances where a confiscation order has been made and where it's not possible for Part 5 proceedings to be brought for the reasons I've given, then to preserve the integrity of the law as between the criminal and the civil jurisdictions, that needs to be respected, and the involvement of an enforcement authority in these circumstances is critical. So whether or not the directors, as in this case, were made the subject of the confiscation orders or the company itself, that would need to be respected, and in terms of considering the civil proceedings and the claim, a proprietary claim made, the civil court would have to have regard to the fact that this is criminal property, and therefore should deny the claim on the basis of illegality in the civil claim. It doesn't really matter whether it's the confiscation order against the directors or against the the company.
Right, but you do say that as far as the illegality defence is concerned, it is essential that in fact there is a confiscation order in place, and in fact there has been a criminal conviction, and not simply the potentiality of a criminal offence having been committed and the potentiality of a confiscation order.
My lady, I think that's right. I don't want to take it outside the facts of this case, where I submit the answer is clear, and the fact that a confiscation order has been made, the proprietary interest was only claimed after it had been made, and we say specifically for the purpose of seeking to circumvent the confiscation order. That is critical. There may be circumstances where it is not so clear that this is criminal property, where there would be under Patel the range of factors. There would be other matters to take into consideration, in particular the fact that there have been no criminal proceedings. But on the facts of this case, we say it's clear because of the existence of the confiscation. So if I proceed to consider stage B, the problem with Aquila's fiduciary duty arguments is that none of them addresses the fact that confiscation orders have been made under Part 2. The principles of fiduciary duty may be inexorable, to use Aquila's word, but they do not place the company above the law, and the consequences of complying with the confiscation orders achieves all the aims of the policies underlying fiduciary duties and more. And the only difference is that Aquila and its assignor VTL will not also benefit from this illegal conduct. Denying the enforcement of this claim will not denude the directors' fiduciary duties of their effect and value. The prison sentences and the confiscation orders meted out to them is sufficient punishment for their crimes, and the sole impact of denying this claim is that VTL and its assignee are prevented from making a claim to the profits of VTL's crime. I now need to deal briefly with some miscellaneous points raised by Aquila in paragraphs 20, 60, 78 and 83 of its case, best addressed in the context of stage B. And they are arguments why the court should enforce Aquila's proprietary interest despite its illegality. First, in paragraph 20 on page 103 of the bundle, Aquila argues the directors had no authority to use the IP rights in an illegal scheme, only in a legal scheme. This is a bad point. The fact that pursuing an illegal opportunity was a breach of fiduciary duty does not make the profits those of a lawful opportunity. Second, in paragraph 60 at pages 116 and 117, the bundle, in an attempt to avoid the problem that it is trying to benefit from the fraud, Aquila seeks to suggest that its claim is a tracing claim for the profits of the IP rights rather than the profits of the fraud. For the reasons I gave at the start of these submissions, that argument's untenable given the findings below and in the criminal courts. Neither the subscription amounts raised by the fraud nor the amounts of those funds that the directors extracted for themselves was in any way generated by or related to the value or the use value of the IP rights. Third, in paragraph 60 little c, page 117 of the bundle, Aquila makes the remarkable submission that no causation requirement is required at all between the breach of fiduciary duty and the criminal profits earned. Therefore, says Aquila, the criminal collection can be ignored. The only authority cited for this bold submission is a sentence in Lord Russell's speech in Regal, Hastings and Gulliver, page 2409 at letter E, which is not concerned with causation at all. And the point is comprehensively answered by Justice Finn's much respected work on fiduciary obligations. And I ask you to read, not now, but if I can refer you to paragraphs 241 and 242 at page 3180 and paragraph 275 on page 3181. There is therefore a clear causation requirement. The fraud on the revenue was not merely part of the wider context, nor was it incidental, as Aquila suggests in paragraph 60 little b on page 117. The fraud plus the subsequent theft from the tax companies was the sole source of the profits. If Aquila wants to lay claim to those profits, it cannot avoid the fact that it is seeking the profits of the illegal tax schemes. Fourth, in paragraph 78, pages 122 to 123, Aquila says that because its interest arises by operation of law and is not the result of a remedial constructive trust, it's not improper to seek priority over third-party creditors by asserting its rights against the directors. There's a short answer to this point, which is that the illegality defence has nothing to do with whether the constructive trust is remedial or institutional. Seeking to rely on the distinction between the two types of trust misunderstands the illegality defence. Just because a proprietary interest may arise by operation of law does not mean that it is right for the court to assist a claimant to enforce it. In the words of Lord Brown Wilkinson in Tinsley, cited with approval in Patel by Lord Mance at paragraph 193, that's page 646 at D to H, the effect of illegality is not to prevent a proprietary interest in equity from arising or to produce a forfeiture of such right. The effect is to render the equitable interest unenforceable in certain circumstances. And Lord Toulson was to similar effect at paragraph 18, page 602H in Patel. To argue that seeking priority is not improper because the interest arises by operation of law overlooks the fundamental point that the illegality defence concerns whether those rights should be enforced, not whether they exist or why they exist. And finally, at paragraph 83 little b on page 124, Aquiles argues that it is more likely the company will have to foot the bill for the consequences of the director's illegality and asserts that policy supports the enforcement of the trust in favour of the company over the unauthorised profits to enable the company to meet such liabilities. The court, VTL, will not be footing any bill for the illegal tax schemes. This is a gains-based claim to the profits of the fraud. So in conclusion, on stage B, there is no, or certainly no sufficiently strong public policy.
Forgive me, Mr. Sutcliffe, why do you say that VTL will not be footing any bill for the tax schemes? There are potential claims against it from the taxpayers, aren't there?
There is no evidence of that, my lord. And this is a gains-based claim. This is not a loss-based claim. No evidence of that. It's the money, any money if this is recovered, goes to the secure creditor, which is a bank, the secure creditor of the holding company. And so that there are no claims, no victims came forward in the confiscation proceedings either.
But no claims have actually been made. There is plenty of scope for claims to be made.
Well, that's not altogether clear, with simply no evidence as to that. And Aquila is keeping 75% of any net recoveries for itself. So only 25% of net recoveries would go to the secured creditor, which is the bank. So simply no question of any claims, even if there were evidence of it. So in conclusion, on stage B, there's certainly, and I'm conscious that the court needs a break, and I'm coming to the right time to break. There is no, or certainly no, sufficiently strong public policy on which the denial of this claim may have an impact. And for these reasons, we say you never get to stage C. And the most important question for the civil court to consider in this case is whether the integrity of the legal system is maintained or undermined by allowing the company to enforce a claim to recover the criminal property that a criminal court has already ordered should be paid to the state. In our respectful submission, there can only be one answer to that question, which is that the integrity of the legal system is maintained by denying this claim and ensuring that there is no longer any obstacle to compliance with the confiscation orders made in the criminal court. So that was all that I proposed to say in relation to illegality, Patel and Mirza, and I was then going to continue with my submissions on attribution.
There we are. Well, that might be a convenient point, Mr. Sutcliffe. We'll take 5 minutes.
Thank you
very much. Mr. Sutcliffe.
My Lord, turning now to attribution.
There's a question coming up from Lord Sales.
Lord Sales.
So sorry, Mr. Sutcliffe, it was really just to pick up on the point that you finished on, that you said that there was no evidence that BTL faced claims from investors, but at paragraph 33 of the Statement of Facts and Issues, we're told BTL faces substantial claims by investors who have also suffered loss. So don't we have to proceed on that basis?
Well, my Lord, there's been a bit of a debate about that. There was no evidence about that. VTL, there simply was no evidence. I think that's taken from a line in one of the judgments, but I'm afraid Mr. Julian Christopher may be able to deal with that in reply. But I'm afraid the position is, my Lord, that it's not a loss-based claim. This is a gains-based claim. And what is clear is that none of this money would go to investors. There's no doubt about that. And there is actually no evidence of any claims having been made. If I could turn now to attribution, we say the CPS's case is simple and straightforward. And as I noted at the outset, given that the directors were the directing mind and will of VTL for the purposes of the fraud, it is indisputable that VTL has acted illegally as a matter of criminal law. It is that illegality which engages the Patel and Mirza illegality defense. That proposition, my Lord,
I do apologize. If the Crown Prosecution Service obtain this money, does it actually go to the investors? You say there's a difference between what would happen in one situation and another, but I'm uncertain as to whether or not the proceeds of crime are then distributed amongst the subsidiary victims.
The procedure, my Lord, as I understand it, is that in the confiscation proceedings, the investors could claim they are victims. There's a procedure by which they can claim they are victims. But if there are no victims that come forward, and there were no victims that came forward, then the position is that the proceeds confiscated go to the state, to the taxpayer. who after all in this was a tax fraud, so it actually is perfectly proper that it should. But my lord, the proposition that the illegality of VTL engages the Patel and Mirza illegality defence would have been entirely uncontroversial before Bilter. It simply applies either the general, so the primary or the general rules of attribution identified by Lord Hoffman in Meridian Global. Aquila says that Bilter has changed the law, and in my submission, that misunderstands and misapplies the rule in Bilter. Can I take each of those points in turn? Aquila's case at paragraph 35, page 108 of the bundle, is that Bilter stands for the proposition that, and I quote, the unlawful acts or dishonest state of mind of a director cannot be attributed to the company so as to afford the director a defence to the company's claim against him for breach of duty owed to the company. We say that misunderstands Bilter. It is not a proposition that you will find in Bilter itself. In the interest of time, can I refer you to the submissions in paragraphs 1 to 27 of Appendix 1 to our case at pages 72 to 79, where we set out what we say is the true ratio of Bilter. You will see there at paragraph 7 of our appendix, page 73, the relevant extract from the head note, which is taken from paragraph 7 of Lord Newburger's judgment at 499 letter G, quoted in our appendix at paragraph 9, page 74. And from paragraph 10 onwards of that appendix, we referred to the relevant extracts of the other judgment. I won't ask you to read those now, but the key point is that all passages expressly refer to a claim for loss by the company as a victim. My principal submission is that extending the ratio of Bilter to gains-based proprietary claims does not work. Aquila says that distinguishing between a loss-based claim for damages and a gains-based proprietary claim is unprincipled. On the contrary, failing to draw such a distinction is unprincipled. It was fundamental to the reasoning in Bilter that the company was not being excused of its legal responsibility for the illegality to third parties, such as law enforcement bodies. We see that peppered throughout the judgment. Bilter itself was a two-dimensional case, narrowly concerned with the private relationship between the company and its director. And that reflects Professor Watts's view, as he says in his 2001 article entitled Imputed Knowledge in Agency Law, Excising the Fraud Exception, which is tab 75, page 3296, where it is only the principal's interests that are at stake, there is generally no cause to deem it to possess its agent's knowledge. This is not a two-dimensional case. It is a three-dimensional case. In this case, Mr. Perrin, one of the directors, was due to comply with the confiscation order made against him. But Aquila made an urgent application for a proprietary injunction to restrain him from handing over to the CPS the assets covered by that confiscation order. That was on the basis that those assets represented the proceeds of sale of the company's IP. This is clear from paragraph 7 of Judge Seymour's judgment, referred to in paragraph 37 of the Statement of Facts at paragraph 41 of the bundle. Sorry, page 41 of the bundle. The very purpose of Aquila asserting a proprietary interest is the priority that interest gives Aquila over non-parties such as the CPS. Had no confiscation order been made, no proprietary claim would ever have been asserted. Proprietary rights are by their nature not personal as between the company and the director. The court is not simply being asked to decide on a two-dimensional basis who, as between the company and the director, has a better right to the property. It's being asked to acknowledge the company's right to specific property in 3D so that it will take priority over the rights of the rest of the world, including against the CPS. And this is despite the fact that from the perspective of the rest of the world, the company is a criminal wrongdoer. And it might well be objected that the court should not be helping the company to enforce its criminally obtained property rights. Where a proprietary claim is enforced, third parties will be affected by it, including a public authority such as the CPS. And that is exactly why the difference between a personal and a proprietary claim is a material and principal distinction from the two-dimensional claim solely between the company and director in Bilter. My Lord Sales.
But isn't it in the nature of a claim that there's a constructive trust, that it's a proprietary claim which ex hypothesi can affect third parties?
Precisely, my lord. That is what I'm saying, and it is the point of that submission is to distinguish this case from Bilter, where there was no such proprietary claim. Bilter was, as I've said, to use the phrase, a two-dimensional case.
Yeah, but forgive me for interrupting. That's the part of the submission that I'm struggling to understand at the moment, because you can have, in a certain sense, a two-party case where the company claims a constructive trust against its wrongdoing directors, but that two-party claim has third-party effects because what's being claimed is a constructive trust which has proprietary consequences. How do you distinguish between a two-party claim and a three-party claim in that situation?
Well, my lord, I'm simply making the point that there is a difference between a right existing and a court assisting its enforcement, especially against third party. Aquila accepts that Patel applies to trust. So when illegality becomes an issue as a matter of criminal law, the enforcement of that right is subject to the Patel analysis. And Aquila hides behind the importance of fiduciary duties, but the content of a duty that the directors owe a company cannot supersede all other considerations.
But I thought at this stage of your argument, you're on the attribution point.
My lord, I am.
It's company claiming against directors, and I rather understood you to be saying that, well, in a straightforward two-party case, yes, maybe you don't attribute the state of mind of the directors to the company. But there's something about this case which means that you do, and it's that I was seeking to ask about, because in the two-party case, what the company is doing is asserting a proprietary right. It's saying the directors acted wrongfully, and the consequence is that all the benefits that they got, in fact, belong in equity to the company. That's the nature of the case.
My lord, yes, I think I'm addressing attribution, but what I'm seeking to emphasize is that attribution is only being considered here for the purpose of the illegality defense. And that is what Bilter was about. And in those circumstances, I'm submitting that now, particularly following Patel and Mirza, one of the factors that the court must take into account that the effect of seeking a proprietary interest, which, as I've indicated, and it's indisputable, was only sought following the obtaining of the confiscation order, is because it affected third parties. Up until that time, the claim made in these proceedings had simply been in persona.
I'm so sorry. When you say the claim made in these proceedings has simply been made in personam, wasn't it always a claim to a constructive trust?
No, that claim was made by amendment in November 2013, following the injunction granted in October 2013 by Judge Seymour, who made it following an urgent application, and as one sees from his judgment, the basis for it having made as a matter of urgency was because Mr. Perrin, one of the directors, was about to comply with the confiscation order. He had 6 months to comply with the confiscation order that had been made in April.
Yes, but I'm looking at paragraph 36 of the Statement of Facts and Issues. At the time when Aquila went before the judge, they were asserting a proprietary claim.
At the time when they went before Mr. Justice Mann, or
no, to get the injunction. Sorry, I've forgotten the name of the judge who granted it now.
Yeah, Judge Seymour. Yes, Judge Seymour. Yes, they had an application to amend. The actual amendment wasn't granted until after the injunction, but the injunction was granted on the basis that a proprietary claim was being asserted.
All right, thank you.
Now, as my Lord will see.
I'm sorry, Mr. Sutcliffe, for bombarding you, but the more I listen, the more I perceive that your case is really that the assignment to Aquila is the unlawful, illegal contract. And why didn't you appeal the orders that were made in October 2013 on that basis? You say they're money laundering, and
well, my Lord, at the time, the confiscation order had been made against the directors, and the CPS was focusing on those confiscation orders being complied with. After the proprietary claim was made, it was defended on the basis that the illegality defence applied, and it shouldn't be permitted to succeed. But I'm not sure that it.
Why doesn't the illegality defence concentrate on the assignment to Aquila?
Well, in my special submission, the illegality defence focuses on whether Aquila, as assignee, should be entitled to enforce its proprietary interest by virtue of the fact that it's seeking an interest over criminal property. And that is the basis on which it is being defended.
Sorry for interrupting, but was, in your submission, the assignment to Aquila an illegal contract?
Well, no, my Lord, my understanding, and I need to look back at it, was that the assignment to Aquila was simply the assignment of such rights as VTL may have against its directors. Those rights cannot be said to be criminal property. Now, as we've identified in Appendix 1 to our written case, the ratio of Bilter expressly refers to the claim being a loss claim, and this is how the learned editors of Bousted and Reynolds have treated this decision in the passage we set out in paragraph 22 of that appendix at page 77 of the bundle. And it's in the context of gains-based claims that the issue of approbation and reprobation arises. A principal cannot take advantage of its agent's illegal acts whilst denying responsibility for the illegality. It's well established in the authorities, and we set that out at paragraph 16 to 21 of Appendix 1 to our case, pages 76 and 77. Starting point is the 1912 decision of Lloyd and Grace Smith. The primary issue in that case concerned whether the fraud took an agent's acts outside of the agency for attribution purposes, and the House of Lords held it did not. Lord McNaughton then went on to state the following principle at the top of page 1726. If I could ask the court to go to page 1726, and I just want to ask you to read one paragraph in Lord McNaughton's speech. It's the paragraph beginning, the only difference, it's the first paragraph down from the top of the page. The only difference, in my opinion, do you have that? Now, Professor Watts, in the 2001 article that I referred to earlier, entitled Imputed Knowledge in Agency Law, Excising the Fraud Exception.
Mr. Sutcliffe, forgive me, we've lost your picture for the moment.
Ah. I think I've come back, albeit a little
In a distant shot, but we're focusing in on you now. Thank you. That's fine.
So I'm just referring to Professor Watts in the same article. At page 3289 of that article, he observed that the core examples of the fraud exception have as a crucial feature the fact that the principal is wishing to maintain the very transaction in which the agent has purported to act. The principal is attempting, in the jargon, to approbate and reprobate the conduct of the agent. And the modern application of this point is the tax case of Mobile Sourcing Limited, which is at tab 31 of the bundle, page 1904, at paragraph 49. In that case, the claimant company sought to deduct input tax in relation to fraudulent transactions carried out by its agent. And the court denied the claim. The claimant could not take the benefit of tax relief on the transactions, whilst also resisting attribution of the agent's knowledge that the transactions were fraudulent. The approbate-reprobate point means that a principal, even if ignorant of the fraud at the time it was being perpetrated, cannot rely on that ignorance in seeking to take the windfall of whatever benefits it offers once it discovers the fraud. And we make the point in our written case, paragraphs 14 to 21 of Appendix 1, pages 75 to 77, using Lord Justice Staunton's analogy of the absent grouse shooting principle. The approbate-reprobate issue arises when the principal comes back from the grouse moor to discover the fraud of his agent in his absence and then seeks to take the benefit of it. The argument is not, as Aquila misinterprets it, that the principal becomes a personal wrongdoer simply by finding out after the event about his agent's illegal acts. The approbate-reprobate issue will not apply in two-dimensional cases where the principal seeks redress from his agent, as in Bilta, or from a third party, as in Singularis, for the damage his agent's acts have caused him. However, it will apply if the principal seeks to take the benefit of his agent's illegality, where he is in law responsible for the illegality. Now, in the present case, Aquila is not only seeking to take the profits of the fraud, it is making a three-dimensional claim. It asserts a proprietary claim to those profits for the specific purpose of obtaining priority over the CPS's confiscation orders, while seeking to hide behind Bilta in order to reprobate the criminal acts of its directors by which the profits were generated. It's seeking to take advantage of its agent's actions whilst disowning the agent's knowledge, as Bousted puts it at paragraph 8-214 in the final sentence on the top of page 3132. And Aquila has no good response to this point, my Lord Sales.
But I mean, isn't the nature of VTL's case against the directors not to approbate what they've done, but to say you've committed a wrong against us, and the remedy for that wrong is that we become the owners in equity of the gain that you have made through wronging us?
The problem with that case, my lord, Aquila's case in that respect, is that they are seeking the benefit of criminal property. They can't approbate by seeking it and then reprobate the fact that this is criminal property for which they, as a matter of criminal law, are liable. And so that is precisely why they are both approbating and reprobating. And they're doing so in order to avoid the illegality defense. So what Aquila say in paragraph 23, page 104 of their case, is that the approbate-reprobate cases only concern third parties. But this is a third-party case. The CPS is the third party, and the very purpose of the proprietary claim is to try to ring-fence the proceeds of crime from the CPS. This we believe, my lady.
But are you relying on the nature of CPS as a particularly significant third party? The directors may have their own creditors, either who are victims of a claim or just people to whom they owe money. So in that case, in a way, every two-dimensional claim has the potential to be a three-dimensional claim, because if they have some money at the end of the day, all sorts of people might pop up claiming to be owed money by them. But is there something about the CPS that singles them out as a third party to whom the court should pay particular respect? Because I thought that your case on attribution, if not on illegality, was that it was not dependent on there having in fact been a criminal prosecution and in fact a confiscation order. It was enough if what the directors had done amounted to a criminal offence, whether or not it had been pursued.
My lady is absolutely right. No, I'm not seeking to put the CPS on some pedestal and say it's in a different position to another third party. What I am submitting is that in circumstances where a proprietary interest is claimed, which affects the world, any third party, CPS happens to be one of those parties, and it is the party which in these proceedings was saying, no, the illegality defence should operate to prevent Aquila from making this claim by virtue of the confiscation order and to stop it relying on its own illegality. And we believe this is the first case since FHR where a proprietary claim has been advanced by a principal to its agent's illegal profits in circumstances where the principal is responsible as a matter of criminal law for the illegality. It's therefore the first case in which the new approach to illegality has had to consider a proprietary claim being used as between principal and agent in order to obtain priority over a third party in this way. Aquila says that if the argument were right, it would apply to FHR. That's paragraph 76 of Aquila's case at page 122. That is incorrect. The point only arises where the principal is trying to avoid the illegality defense, stopping him from taking the benefit of the crime by reprobating his agent's knowledge. In bribery cases, such as FHR, the illegality defense was irrelevant, was not alleged that FHR had committed any offence, and it was not alleged that FHR was seeking to take the benefit of such events while reprobating its agent's knowledge to avoid the illegality defense. Aquila further contends that it is not reprobating the director's knowledge except against the directors. That's paragraph 77 on page 122. With respect, that is just wrong. It is approbating and reprobating against the CPS for the very purpose of frustrating the confiscation. Aquila's argument simply fails to address this proprietary interest point. And Aquila is seeking to avoid the consequences of its illegality, not only in respect of the directors, but also against the world, including the CPS. That's the first point on attribution. The second is not only does Aquila's case misunderstand Bilter, but it misapplies Bilter. The principal error made by the lower courts was to refuse to consider the context of the confiscation orders that had been made against the defendant directors, in this case, under Section 6 of POCA. We say that if attribution is a contextual exercise, that was the relevant context to consider in the dispute as between the parties to this appeal. It was a misapplication of Bilter to decide the attribution point divorced from the context of the confiscation orders. The court needs look no further than the judgment at first instance in this case to see the problems that arise if the focus is on attribution alone as an abstract exercise from the Patel exercise. I ask you to look at paragraph 56 of Mr. Justice Mann's judgment, which you'll find at page 188 of the bundle. And if I could ask you to read that paragraph.
Sorry, which paragraph?
Paragraph 56.
56,
page,
thank you very much.
Page 188.
Yes, thank you.
You will see that his lordship refused to take into account the later confiscation proceedings because he said that attribution cannot vary over time. If the Bilter analysis carries that limitation, it's clearly inconsistent with the Patel assessment. That highlights the problem with using the contextual attribution exercise to do a job that's better left to the illegality defense, which is specially designed for the purpose. We say that most of the central reasoning in Bilter was addressed to arguments about why attribution should not be allowed where the consequence of doing so was that the claim would fail for illegality. They included the same policy arguments that are now advanced by Aquila, namely the supposed immutability of fiduciary duties, the obligation that the objection that it was the director and not the company who was the moral wrongdoer. But as Lord Toulson and Lord Hodge observed in their judgment in Bilter, paragraph 166 on page 548, the question of attribution was not the real issue in the case. Rather, it was whether it is contrary to public policy, the company acting through liquidators on behalf of creditors should be allowed to enforce its claim against the directors for breach of their fiduciary duty to the company. The defence of illegality, my lord.
So, am I understanding you correctly that you say the principle of attribution could change in relation to this claim depending on the timing and the events at the time a claim is brought? So, if the company, VTL, had appreciated what had gone on and had brought its civil claim before the CPS and prosecution authorities appreciated what had gone on, so before a prosecution, am I right in thinking that you accept that the knowledge of the directors is not attributed to the company for the purposes of that claim, but that what makes all the difference is that the CPS has woken up to the fact that it might have to bring a criminal prosecution, and that changes the attribution rule? Is that right?
Well, my lord, it depends what facts, different facts one's looking at. What I certainly...
Well, take the fact that I've just put to you, that the company, the penny drops with the company before it drops with the CPS. So the company brings its civil claim for a constructive trust before the CPS has woken up to the fact that it ought to be bringing a prosecution. You seem to be saying that attribution in that situation doesn't apply. The company can sue, the directors are treated as different. But as soon as the CPS then, well, I'm not quite sure what the critical event would be, bring a prosecution or seek a confiscation order or get one, something within that spectrum of possibilities changes the attribution rule. Is that right?
My lord, my submission is simply this. You look at attribution for the purpose of the illegality defence. And so for the purpose of, on the facts that my lord has just postulated, if it is a two-dimensional case, as I called it, as between the company and the director, then the court would be looking at a different context. I'm not saying how it would treat the illegality defence in those circumstances if it was raised by the directors. If the company had suffered a loss, then the likelihood is it would go the same way as Bilter. Or if a third party had caused the loss through its negligence, as in singularis, then again, it would go the same way as Bilter. But one's not looking at the crime, you're looking at the crime itself, you're looking at attribution for the purpose of the illegality defence. And the defence of illegality is of course now governed by Patel. And we submit, it is clear, as my Lord Lloyd-Jones said in the Stoffel case, at paragraph 26, and this is page 2501 at B, the essential question is whether to allow the claim would damage the integrity of the legal system. And with that aim in mind, as we have seen, Patel allows a full consideration of reasons for and against the claim failing for illegality. That process of consideration will include all of the concerns the court previously considered as part of the attribution exercise in Bilter.
Sutcliffe, there's a question from Lord Burrows then.
Oh, sorry, my lord.
Yes, thank you. So can I just be clear about the submission you're making? It sounds as if you're saying that in the light of Patel and Mertzer, we should treat the Bilter case as subsumed within all the factors that now must be taken into account in Patel and Murta. So we start off, as I would take it, with the old law on attribution. We look at directing mind and will. We don't bother about what was said in Bilter. We go straight to Patel and Murta, and hey presto, that's the end of it. We can more or less forget Bilter. Is that the submission?
My lord, let me, for illegality, yes it is. Not for estoppel or acquiescence, but given that I've run...
Bilter was a case on it. Bilter was precisely on illegality.
Yes, no, my lord, you're absolutely right. That is what I'm saying. Can I just conclude my submissions? I'm very near at the end. Your lordship has preempted me, because that is where I was going. My submission is that following Patel, there's now no need to have a special attribution inquiry for the illegality defence, as distinct from the usual Meridian global approach taken to attribution for the purpose of criminal responsibility. After Patel, acknowledging that the company has committed an illegal act does not mean that the illegality defence will succeed irrespective of other considerations. So the court shouldn't approach the application of the Bilter exercise as an additional and separate exercise to the Patel exercise and apply a different, more limited set of factors. The problem with doing that is that Bilter will produce results that are inconsistent with illegality policy. And my submission is, if the Supreme Court does not address this issue now, there is a real danger that Bilter may be misapplied and thereby impede proper consideration of the integrity of the law under the illegality defence that exists following Patel. The fallacy that needs to be corrected is any suggestion that Bilter can act as the gatekeeper to Patel, and that the outcome of Bilter dictates whether or not the claimant has acted illegally, so as to allow or prevent consideration of all the relevant factors under Patel. And our submission is that unless this court makes it clear that attribution cannot act as a gateway for the illegality defence, courts will either have to justify the inconsistent outcome between Bilter and Patel, or they will have to conduct two parallel exercises to ensure there's no conflict. Singularis, the one case that has considered Bilter in the context of illegality since Patel, took that dual assessment route, as my Lady Rose will know. We submit that doing the balancing exercise twice over does the law no credit. It is not capable of rational justification, and it can lead to odd outcomes, as in this case, because of the misperception that the attribution exercise takes into account a more limited range of factors than the illegality defence. I emphasise that the CPS does not suggest that fiduciary duties should simply be disregarded or undermined. Under Patel, due weight will be given to the importance of a company's ability to recover the proceeds of a breach of fiduciary duty. However, in this case, those considerations are outweighed, and the greater interest here, the real public interest, is in confiscating the proceeds of crime. Those are my submissions, unless I can be of any assistance. Yes, my lord.
Mr. Sutcliffe.
Yeah, just
Sufficient for sales.
I just wanted to be clear. Are you inviting us then to overrule Bilter?
No, my lord. Just to clarify that for the purpose of the illegality defence, Bilter, the attribution issue raised by Bilter has to be considered in the context of Patel. Patel is now the decision which courts should adhere to and follow in the consideration of illegality. And Bilter, the problem with Bilter is that it's in danger of being misapplied or misinterpreted, as we would suggest has happened in this case.
All right,
Thank you, Mr. Sutcliffe. We're going to take a few moments to take stock of where we are, and so we'll withdraw from this transmission, and we'll be back shortly.
Thank you.
Thank you, Mr. Sutcliffe, for your submissions. Mr. Ritchie, we'd like to hear you generally, please, but we'd like to hear you in particular on the following matters. The first may be a matter for you, or it may be a matter for Mr. Evans. That issue is the operation of POCA in circumstances where it emerges that there is a claim for a constructive trust, how that is dealt with within the machinery of POCA. We understand that when confiscation proceedings are on foot, it's possible for a third party to intervene in those proceedings. But we would welcome assistance on how such an issue can be dealt with, as in the present case, where the third parties don't come forward initially, but only at a later stage. We would also welcome assistance from you in particular, please, in relation to the issue of money laundering and my Lord Stephen's question of Mr. Sutcliffe this morning as to whether the transfer to Aquila was a trade in the proceeds of crime. And we appreciate that we have eaten into the time allowed for you to address us by almost 25 minutes. We would like, if possible, please, to sit again at 1:45 in an attempt to make up some time.
My Lord, I'm grateful. Does your Lordship wish to rise now and start at 1:45, or carry on till 1? And
no, I think we will use the time that's available until 1 o'clock, and then we'll resume at 1:45.
Yes, of course.
Thank you.
In which case, I will start with just the broadest overview. Unlike Mr. Sutcliffe, we submit that the starting point here is attribution, and the reason for that is because of the amount of care and analysis that this court has already given to the issue and resolving, we say, the way in which the law should look at issues of attribution. We say context is very important, and the way in which context is being used and understood by the CPS is wholly inappropriate. We see from other cases that have been recently decided, the Red Star case in Singapore, the dangers if context is understood to be an issue at large that can be dealt with on the facts of each and every case of directors' duties afresh, looking at attribution afresh, looking at illegality afresh. We accept that the ratio of Bilter was a claim about loss, but we do not accept that the reasoning or the rationale is so limited, and we say that that reasoning and rationale therefore determines the position in this case, having regard to the nature of the claims that were being brought. We say that heavy reliance is obviously placed by the CPS on the operation of the POCA regime generally. And we say that as regards that, one has to understand that the whole regime under the Proceeds of Crime Act, whether under Part 2, 5 or 7, are not intended to define or rearrange property rights. The Act conforms to property rights and legislates for their consequence. And we therefore say that it is wholly inappropriate for this court in this case to be influenced by the provisions of POCA in looking in terms of the common law of illegality at claims brought by a company against its director, again on adventitious grounds which could depend on the facts of every given case and give rise to immense uncertainty and inconsistency in the development of the law, where there is simply no need to do so. Pocket is a sophisticated act, it is a nuanced act, and in dealing with the questions which you have specifically posed me this afternoon, I will attempt to assist in dealing with those particular points in showing how it works and in showing that it works coherently with the operation of common law and equitable rights. We therefore say that there is no need on the facts of this case to apply the Patel and Mirza case, but that if you did, you would find there to be no incoherence between the common law and FOCA or any other relevant policy consideration in this case, and that having regard to the policy objectives of directors' duties, you would not go to stage C. You would reach the same decision under Patel and Mirza that the Supreme Court has reached under Bilter, and you would determine that claims by companies against directors for breaches by directors of their duties to the company are claims where their own wrongdoing is not attributed or knowledge to the company. My Lord, I had plainly anticipated a longer run-up before lunch, but I wonder whether by way of those introductory remarks it might now be an appropriate moment to break and get settled into more of the detail in the afternoon.
That's very helpful, Mr. Ritchie. Thank you very much. We'll resume at 1:45, please.
Grateful.
Thank you all very much.